Welcome, everyone. Thank you for listening to the Council of Institutional Investors, Voice of Corporate Governance, the number one best corporate governance podcast as determined by Million Podcasts. I'm your host, Jeff Mahoney, General Counsel of CII. Our topic for this episode is an article titled Delaware's Agency Problem. And my special guest today is the author of that article, Charles K. Whitehead, the Myron C. Taylor Alumni Professor of Business Law at Cornell Law School. Welcome, Professor Whitehead. Thank you for joining us today.
Thanks very much. Great to be here. And, the title they've given me for my chair is so long, it's probably 2 chairs. But in any event, it is what it is. It's great to be here.
Professor, your article argues that Delaware's lawmaking process for amending their corporate law statutes has a second-order agency problem. Before we discuss the problem as you see it, can you give our listeners some background and an overview of Delaware general corporation law, including why that law is so important to institutional investors in our capital markets?
So that's a great question. It's a large part of what I teach, actually, when I'm teaching corporate law here at Cornell. As you know, Delaware sits at the center of American corporate governance, and in many ways, in light of the number and the size of the companies that are incorporated in Delaware, really it sits at the center of global corporate governance. Roughly 2/3 of Fortune 500 companies and the majority of U.S. public corporations are incorporated in Delaware. The dominance is not accidental. It reflects a system in which legal expertise, institutional reputation, and economic dependence on franchise taxes each sustain Delaware's preeminence in the corporate governance space. The state's annual revenues rely heavily, up to 40% in any given year, on revenues and fees generated by its corporations, creating strong fiscal incentives to preserve its appeal as the jurisdiction of choice for incorporation. The state's appeal lies in its sophisticated judiciary, particularly the Court of Chancery, and also in its corporate code, the Delaware General Corporation Law, sometimes referred to as just the DGCL, which allows boards and investors to structure relationships with a fairly high degree of clarity and flexibility. Over the decades, the Chancery Court's case law has evolved into a kind of common law of corporate governance, with precedents that are routinely cited in other jurisdictions and other states, in federal courts, and really around the world. For institutional investors, Delaware law matters because it effectively sets national corporate governance standards. When the Delaware legislature or the courts in Delaware change Delaware's corporate rules, say on fiduciary duties or shareholder rights or conflict of interest transactions, those changes ripple throughout the entire marketplace. As I'm sure you're aware, there have been periodic efforts by other states, most recently Texas and Nevada, to attract incorporations away from Delaware by offering things like lower costs or more management-friendly statutes. But despite recent concerns that Delaware may be losing its crown, it continues to dominate because of its predictability, its judicial expertise, and the established body of case law precedent. So although Delaware is a small state, its corporate law operates as a form of national corporate policy. That's why the integrity, the legitimacy of the lawmaking process in Delaware are so critical to investors and also to market confidence.
Professor, can you describe how Delaware general corporation law is currently amended? And what exactly do you mean when you say the amendment process has a second-order agency problem?
So this is kind of like looking behind the curtain in The Wizard of Oz, really beginning to understand the process by which new laws, really statutory amendments, are made in Delaware. So amendments to the Delaware Code, in fact, typically do not originate in the Delaware legislature itself. Rather, they originate in a small committee of the Delaware State Bar Association, known as the Council of the Corporation Law section. And the reason for this has to do with the sophistication of many of these laws. It requires a level of expertise that the legislature is happy to rely upon the council for. The council's members are not elected. They are not required to disclose any of their deliberations publicly, and they do not answer to the shareholders whose interests their laws typically affect. Rather, they're drawn primarily from a handful of leading Delaware law firms, whose clients often are the very corporations most directly impacted by the Delaware Code. That concentration of expertise and influence gives the council a remarkable level of continuity and control over the content of Delaware's corporate law. In a nutshell, what the council does is they draft proposed statutory changes or new statutes. They circulate them among a limited group of practitioners, and they do so without public comment or input. The process is fairly opaque. The reason they do this, at least when the council talks about this practice, is to avoid a sort of external influence, to try to sort of keep things internal to the council. The problem, of course, is that it's not possible for non-council members to access council minutes or deliberations or to be involved in the process. The amendments are often approved by the Delaware Bar after the council has passed upon them, typically without modification, before going to the Delaware legislature, the General Assembly. The legislature nearly always enacts whatever comes out of the council, usually unanimously and with little or no debate. There are rarely public hearings or published legislative records, and even significant reforms, such as most recently the amendments to Section 144 of the Delaware Code, can move from conception to enactment within just a few months. In effect, the council's recommendations function less as proposals or recommendations, but really more as finished products. The process is efficient because it moves through the council fairly quickly. And again, there's a high level of expertise there, but it's also insular. That's what I mean by a second order agency problem. In corporate law, a first order agency problem typically arises between shareholders and managers who are acting on behalf of the shareholders. The concern is that managers may pursue their own interests at the expense of the shareholders, who may not be able to oversee the manager's day-to-day activities. Much of Delaware's framework around fiduciary duties and shareholder rights is designed to address exactly this kind of conflict. A second-order agency problem occurs one level higher. It arises when those who have designed the law, the agents of the state and the marketplace, if you will, have incentives that may not align with the broader public interest. Delaware's drafters on the council are highly capable, but they also are repeat players who represent the corporations, the investors, and of course the law firms most affected by the Delaware Code. Without procedural safeguards like transparency or the ability for the public to comment, the risk is that laws will be tailored to the insider's preferences rather than to what benefits Delaware corporate law and corporate governance in the longer term. In that sense, as I describe in the paper, the process that produces Delaware's corporate statutes can mirror the very agency costs the law is intended to constrain, except now they occur within the lawmaking process itself. The point here is not that the lawmakers are acting in less than good faith, but that the institution within which they operate lacks procedures that permit multiple stakeholders, including the shareholders whom the laws in many cases are intended to protect, to participate in that very process. It's a structural concern. Even well-intentioned actors can reach suboptimal results when incentives and accountability are misaligned. Of course, Delaware and its lawyers have an interest, an economic interest, in ensuring that Delaware remains the most attractive jurisdiction for corporate law. But that does not necessarily mean it produces the most optimal law. You can think of Delaware corporate law as a kind of public good. Its benefits are shared by a wide constituency, including the council's members. At the same time, council members face their own personal incentives, their own private incentives to pursue marginal private benefits. And these can include, for example, advancing their own reputational interests or advancing their clients' interests, even at the risk of departing from Delaware's goal of effective corporate governance, and in the process, reducing the long-term value of Delaware's corporate law as a public good. Because the benefits of influence are concentrated in the council members, and the costs are diffuse, shared amongst all the various constituencies that are sort of working in or around Delaware, insiders, for example, council members, can rationally pursue short-term advantages even when the collective system suffers, as long as the perceived benefits exceed the costs to council members and others who are involved in the lawmaking process. The incentive to favor private interests can persist. And that's what gives rise to our second order agency concern. Again, it's institutional, it's not tied to individual members, but it reflects the fact that you have this insular system that doesn't really permit outsiders, and in particular those who are impacted by the law, to step in and oversee the process and participate in the process by which new laws are enacted.
Professor, one of the examples you provide in your article regarding Delaware's second order agency problem was the process used in the spring of 2025 to amend Delaware General Corporation Law Section 144 related to conflicted transactions of controlling shareholders. Can you provide our listeners with some background and an overview of the requirements of Section 144, the proposed amendments, and why you believe the process used to amend Section 144 was problematic?
So Section 144, as you mentioned, it's Delaware's recently amended statutory safe harbor for transactions that involve conflicts of interest, such as, for example, when directors are on both sides of a transaction. Historically, 144 was intended to validate conflicted transactions if they were approved by disinterested directors or shareholders or were otherwise found to be entirely fair to the corporation. The provision was enacted originally to codify a common law doctrine that not every self-interested transaction is necessarily void or voidable, so long as procedural or substantive safeguards exist to ensure fairness. And so its goal was to give directors and officers a clear framework for cleansing conflicts, while at the same time preserving the judiciary's role in assessing the fairness of those transactions. Following the Delaware Chancery Court's second significant opinion in the Tornetta v. Musk case, often referred to as Musk 2, this was in December of 2024, Delaware decided to amend Section 144 to extend the statutory safe harbor to transactions involving controlling shareholders, provided that those transactions met certain procedural requirements. The revised statute also codifies definitions of controlling stockholder and independent director for the very first time, terms that had previously been developed in Delaware through case law. Perhaps also in a nod to Mr. Musk himself, the new law provides that a stockholder owning less than 1/3 of the corporation's voting power, irrespective of the other influence that stockholder may have, is not going to be presumed to be a controller. And the result is this threshold narrows the category of fiduciaries that are going to be subject to entire fairness review. The new framework also broadens the availability of cleansing mechanisms available in conflict transactions with controlling shareholders. Those transactions can now be ratified after the fact, through post hoc approval by disinterested directors or shareholders, so long as disclosure and independent standards are met. This kind of a mechanism, this sort of post hoc ability to cleanse, is something the Delaware Chancery Court has often treated with skepticism. In fact, in Musk 2, the chancellor specifically addresses this concern. And the reason is because post hoc ratification really weakens the deterrence and the accountability function by allowing boards to cleanse defective processes after the fact rather than having an incentive to prevent them up front. The substance of the reform is debatable, but the real concern addressed in my paper was the process by which Section 144 was amended. The amendments were introduced within weeks after the Musk 2 opinion was issued in late 2024, with little public discussion, no published drafting history, and virtually no opportunity for institutional investors or academics, or for that matter, the broader Delaware bar, to comment on the draft statutory amendments. The pace by which Senate Bill 21, which is the bill that included Section 144, the pace by which SB 21 was enacted, from a Chancery Court opinion to a signed statute overriding that opinion from December of 2024 to March 25th of 2025, so really a remarkably fast period of time, was quite substantial, particularly when you think about the fact that it was redefining some core fiduciary principles. Hearings were brief, they were dominated by testimony from members of the council, and only a handful of opposing witnesses, or witnesses that had concerns over 144, including yourself, Jeff, were permitted to actually allow to speak, and even then only for a limited period of time. The process by which 144 was drafted and adopted provides a vivid example of a second-order agency problem. Here we have a major change in corporate law that's being made through a process that lacked basic procedural transparency. Even if the outcome was reasonable, and we can leave for another day, discussion of the substantive concerns that Section 144 raises, the way it was achieved undermines confidence in the impartiality of the Delaware lawmaking process. The concern is heightened by the fact that the amendments were enacted in direct response to the Chancery Court's Musk 2 opinion, before the Delaware Supreme Court even had the opportunity to review that opinion. In effect, the legislature acted to neutralize a pending judicial interpretation of fiduciary law, blurring the line between the role of Delaware's legislature and the role of its very highly regarded judiciary. I would argue as well that by effectively legislating around an active judicial controversy and narrowing on top of this who qualifies as a controlling shareholder, Delaware signaled to the general public both its responsiveness, but also its vulnerability to insider influence. And so, putting aside again the substance of 144, there are certainly concerns there. The process by which this was pushed through, you sometimes think about these types of fundamental changes taking months and months, if not years, to sort of go through a deliberative process. Again, in this case, it's done really in weeks. Gives you a strong sense that there was a strong insider preference for this provision, 144's amendment, even though it may not necessarily have reflected the broader interests of Delaware corporate law, or for that matter, the other stakeholders who rely upon Delaware law as part of protecting, for example, shareholder interests.
Professor, your article includes a list of specific procedural reforms that you believe would resolve Delaware's second-order agency problem. Can you discuss your proposed reforms? And to the extent institutional investors listening to this podcast or reading your article want to support the adoption of your reforms, what specific actions do you recommend they should take?
So first, I would encourage everyone to read my paper. I practiced for many years. I've moved into a world now where the number of downloads of my paper matters. So I'd encourage folks to read it. In the paper, I have a number of specific reforms, but if I were to sort of generalize them, I think you can summarize them in two parts. The first is transparency. The council process needs to be amended. They should publish proposed statutory changes. They should provide supporting commentary. And importantly, there needs to be a legislative record that explains the policy rationale behind each amendment or each new statute. This would make it possible for shareholders and academics, policymakers, others, to understand why particular amendments were advanced, what alternatives were considered and discarded, and why and whose views ultimately shaped the final language. Essentially, introducing a traceable legislative history where none really exists at this point. I will say a number of years ago, I tried to get access to some of these materials, and it's very clear that the council will not provide them to the general public, again, on the basis of not wanting to have outside influence, wanting those on the council to be neutral in their deliberations. But it does have this other problem of, because of the opacity, not permitting people who are interested in understanding a legislative change to know the history and what prompted that change in the first place. The second general reform, or the second part of these reforms, really is a notice and comment process that I recommend should be modeled on the Delaware Administrative Procedure Act. I mean, the fact of the matter is that the council, even though it is a private organization, really is an extension of the legislative process. It's not an agency. Perhaps it provides advice, I suppose, is the formal way in which you might position it. But there are examples of bodies that regularly provide recommendations to, for example, at the federal level, federal agencies, also being subject to a formal notice and comment process. And Delaware has a pretty good process in its own APA. Now, that doesn't mean turning corporate law into some sort of a bureaucratic mess. Delaware is rightly known for the speed with which it can respond to market change, but it does mean that we should allow affected stakeholders, including institutional investors, to review and provide meaningful input before statutes or amendments are finalized. Even a short structured comment period, say 30 days, for example, would allow feedback from investor coalitions, corporate governance experts, and corporate counsel without slowing down Delaware's legislative tempo. Together, these steps would introduce a measure of procedural accountability without undermining Delaware's flexibility or responsiveness. And really, by focusing the public on what Delaware is doing, that has a self-reinforcing effect. You don't need courts to step in and oversee what is being done by the council or by the Delaware legislature if everything is public and all the different interested stakeholders are involved in the process. This would help realign incentives, shifting Delaware's lawmaking equilibrium from a model that is insider-dominated to one that balances expertise with, more importantly, legitimacy in the lawmaking process. For institutional investors, I believe the most effective step is engagement. Investors should ask Delaware companies and their counsel to support a more transparent lawmaking process. As you know, institutional voices matter. And Delaware's legitimacy as the gold standard in corporate law really very much depends on investor confidence. Institutional investors can make transparency a standing item in whatever their engagement is with Delaware corporations. This could be through direct dialogue with the board, public letters, coordinated investment statements, investor statements, but it should be part of a regular set of points that institutional investors should make when dealing with Delaware corporations. Most likely, a meaningful effort to advance transparency in Delaware's lawmaking process will really need to be driven by institutional investors themselves. And again, this will be done through engagement, public comment, and really sustained advocacy for reform. By urging Delaware to adopt a more open, a more accountable process, institutional investors can help preserve the very qualities that make Delaware corporate law so valuable and really make Delaware not just a model for good corporate governance, but Delaware as a model for how good corporate governance laws should be made.
That concludes our podcast episode. On behalf of the Council of Institutional Investors, I want to thank my special guest, Charles K. Whitehead, the Myron C. Taylor Alumni Professor of Business Law at Cornell Law School. If you have any questions or comments regarding this podcast, please feel free to contact me at Jeff, that's Jeff, at CII.org. Until next time, I'm Jeff Mahoney. Thanks again for listening to The Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.